Now we're going to move on to the tax law update that Vince and I worked on. And you can see our pictures up there. That's me with a tie. You're not going to see that very often. So let's see what we're going to talk about today, because there have been some things, particularly new development. So we talked the last couple of years about the Secure Act. This is the law that governs how IRAs work, when you have to take your required minimum distribution, when you send that IRA, the leftovers, to your kids, how long do they have to pull it out? And so there's been a recent change, and we want to notify you about that today. We're going to talk about where we stand currently with estate taxes and where they're headed. We're starting to get closer and closer to the sunset date. So the current estate tax law was passed in 2018, and then it had a sunset of 2026, and here we are at 2022. So we're going to talk about that. And then because of that sunset, there's some planning opportunities that we can get at, and we want to talk about those. So let's start with the Secure Act. This just got clarification in 2022. Now, this law went into effect for deaths starting January 1, 2020. And if you were in the wrong spot as I was, I have had to start taking my RMDs at 70 and a half. But some of you who have just had birthdays can start taking your required minimum distributions at age 72. But the new change in the law affects beneficiaries of inherited IRAs. And so the pundits have told us initially, when this act was passed, that most of the kids that are receiving an inherited IRA will have a 10-year time period after their parent dies to withdraw the money. We thought it could be any time in that 10-year period, including the last day of the 10th year. I could wait all the way to the end. There are no required minimum distributions. It turns out the IRS didn't think that. And so they issued a guidance. Did that advance at all? No? There we go. So it's in red. What they said was, if you're a parent, had already started taking the required minimum distributions, which means they were at 70 and a half a few years ago, or 72 now, if they're pulling money out, then and you inherit that IRA, you also must start taking required minimum distributions the year after the death for the next 10 years. And it's you use there's a table for life expectancy. So if I'm 41 when I inherit, I'll have a longer period of time to pull the money out in terms of the dollars that come out. Lower amounts will be in the required minimum distributions than if I were older. But we pretend as though we're going to follow that life expectancy table all the way to the end of your life. But what happens is, in years 1 through 9, we use the table, and in year 10, you have to pull the rest of the money out. And since we advised our clients that you didn't have to take the money out when people died, we told the kids, you don't have to pull money out, you can wait as long as you like, up to the 10th year. We're going to have to tell all those people that's not so. The IRS did one nice thing. What they told us is, we know people may not have taken the required minimum distribution in 2021 or 2022, and we're not going to impose the penalty for failing to withdraw. You still have to take them. So if you inherited an IRA, but you'll have time to recover from that problem. Let's move on to the estate tax. So again, in 2018, the exemption was set at $10 million. In English, the exemption means if you don't have up to $10 million in your estate, you don't even have to file an estate tax return, much less pay the tax. So the exemption is indexed for inflation, and it started off initially. And right now, in 2022, the exemption has grown to $12,060,000. And the IRS has paid attention to the idea that there is inflation. And so they have, since this was indexed for inflation in 2023, the exemption has jumped to $12,920,000, nearly $13,000 or $13 million per person. So if you're married, you double that, right? You get $24,000 almost, or $25,000, 26 it is, $26,000 next year. So, and married couples can transfer unused exemption to each other. So husband dies and then leaves everything to his spouse, which means there's no estate tax because of the unlimited marital deduction. So basically the husband did not use his exemption. He gets to transfer that unused exemption to his spouse, who now can walk around with a $26 million exemption for when she passes away. So that's going to be a permanent feature of the tax law. But what's going to happen is in January 1, 2026, this exemption will roll back to half its amount. So it's $5 million indexed for inflation. Our estimates are that it will be at $7 million per person. So if you're a couple, that should be about $14 million. So what we're looking for is people who are starting to hit that $7 million or more in a taxable estate, and even more urgent if the combined estate is over $14 million. So let's take a look at some of the things that Congress has done. The tax rate for estates has been stable. It's 40%. If you get over the exemption amount, 40% of the money goes to the government. The other 60% can go to your kids. And then in 2021, we actually want to look backwards and see what Congress has proposed but then rejected. And so when we were trying to fund this infrastructure bill, there were all kinds of proposals floating through Congress. One of them was including what's called a grantor trust in the taxable estate of the individual. Now let me tell you what a grantor trust is, and you won't remember it, but I think you'll understand it pretty well right now. And that is, a grantor trust is not yours, or it is yours for income tax purposes. So if the assets in the grantor trust throw off interest, dividends, capital gains, that goes on your tax return as the person that created it. But people do this so that they can get things out of their taxable estate. So it's you own it for income tax purposes, but you don't own it for gift and estate tax purposes. It's out of your estate. And so Congress is talking about starting to include those grantor trusts in the taxable estate of the individual. But they were willing to say that if you had a grantor trust before the effective date of our statute, then that's grandfathered in. So we're going to be looking to see if these concepts resurface. Congress also looked at getting rid of the step up in basis. A step up in basis, I think we talk about this at almost every program. It's so hard, it's easy to say, but hard to understand. When you own something that you bought for $100,000 and it's grown in value to $200,000, the basis in that asset is the $100,000 you paid. And so the step up in basis is something that happens when you die. We upgrade the basis to date of death value. So it has the effect of, think of it this way, it just erases built up capital gain for your beneficiaries. So that, again, Congress was looking at limiting that, and we'll see if that happens or not. Let's take a look and see where we are on the gift tax. In 2022, if you make a transfer while you're alive, and that's the only difference between the gift tax and the estate tax. If the transfer occurs while you're living, it's the gift tax. If the transfer occurs after you've died, it's the estate tax. It's the same tax. And so there's a special exemption for lifetime transfers. It's called the annual exclusion. People remember it as being at $10,000, but it's been indexed for inflation all these years, and it's grown to $16,000 per person per year. So if you're married, you can transfer $32,000 to a son or daughter, and if you want to include their spouse, now it's $64,000 that you can transfer. Husband transfers half of the money, wife transfers the other half, and then it's split between your son and daughter-in-law. And then in 2023, finally this exemption is going to go up to $17,000 per year. And people always wonder what happens when I make a gift bigger than the exemption, the annual exclusion amount. Nothing. You just have to file a gift tax return and report it. But until you hit the exemption amount of $12,060,000, there's no tax to pay. So it's just a reporting requirement. So first you can get away with no reporting if you use the annual exclusion. Then you got to report from 16,000 all the way up to 12,060,000. And then when you go over 12,060,000 during your life, get out your checkbook. So the gift tax is not terribly worrisome. But now that you know these things, there's a technique that we look at for individuals who are married. And we're going to talk about, this is just one of the many things you can do. It's called a SLAT, not a charming name, S-L-A-T. And we're going to see what a SLAT is, how does it work, and what are the pluses and minuses. So what is a SLAT? Well, the letters stand for Spousal Lifetime Access Trust. And what the technique is let's say we've got a couple with a $15 million combined estate. So each of them have about $7.5 million. And the issue is, right now, each of them have a bigger exemption, a $12 million exemption. Should they use it if they can? Because it's going to drop in 2026 to $7 million. So it's a use it or lose it idea on the big money. So we look at transferring, if we can, over $6 or $7 million out of one person's estate. That's what the SLAT does. But the nice thing about that type of trust is it allows your spouse to access, use, and enjoy the money. So I haven't really gotten it out of my estate for purposes of being able to use it, but it is out of my taxable estate in a trust for the benefit of my spouse. So let's talk about how this thing works. So first of all, we have to figure out who's going to make the gift, husband or wife. And often it's both of us who will make a transfer. We have to pick a trustee. Can it be your spouse? So I'm making a spouse or a trust for the benefit of my spouse. Can she or he also control it as trustee? Not a great idea. It's a bit dangerous. Things can go wrong a little bit easier, but you still can do it. But it's better if you have an adult child with their brain connected, and let them serve as trustee, and they'll make sure if money needs to get over for the use of the couple, that I'm the person that gets the distribution, or I decide what the distributions are for the spouse. And things just work great. So the beneficiary typically is going to be the spouse in some fashion or another during that spouse's lifetime. So each of the spouses can create one of these for the other if you want, but of course the IRS thinks that that's a dangerous thing to do. So they have a doctrine that they don't want you to violate called the reciprocal trust doctrine. Don't make a deal with your spouse. I'll set one up for you, you set one up for me, and then we'll not lose any access or control. And it turns out you can still do it, but you just have to make the trusts different enough from each other that the IRS will say that you didn't violate this reciprocal trust rule. They have not set out nice, clear guidelines for us to work with. So we have to do all kinds of things to make sure that that doctrine isn't applied against us. So, for example, the way you name the trust, you want to kind of have it match up with what we're trying to do. So one of the names that we often use is the spousal support trust. So if it's a Smith family, the husband is setting up this trust for the benefit of his wife. It's going to really include pretty much every bit of access that we want that spouse to have to support his or her lifestyle. So that's the support trust. And then if we want to do a slightly different trust for her trust for the benefit of him, it might be a family legacy trust, where he's one of the beneficiaries, but not the only beneficiary during his lifetime. It can be for the kids, it could be for my parents. But the one thing that we do in both trusts is we'll usually make the trust going to the kids after the spouse dies identical to the trust that we see in your revocable living trust so that we can merge them all together. So it's a trust really meant to make sure that our spouse has continuing access to the money that I have now technically transferred out of my taxable estate. So the different functions will change the access to the spouse. The things that we tinker with are on the board. Income, do you get all the income, or do you just get income in discretion of the trustee? Do you get principal? Often that is the right thing to do for HEMS, which is health, education, maintenance, and support. Practically everything you can think of. You might have different provisions for whether if my spouse remarried after I died, would I require him or her to get a prenuptial agreement or not? Do I want to allow them to appoint property, that is to direct property to others in the family? Yes, I can do that during lifetime and at death. So we tinker with all these things, and husband's trust for wife and wife's trust for husband will vary on these subjects. But the idea is we don't want to close off the access to the spouse. So one of the things that we can do to avoid this reciprocal trust doctrine is certainly set the trusts up on different days. Different months would be even better. Different years, all the better. And right now, we're obviously, when we set these up, we're doing them in December, and then we can move into January or February, and that'll help make things look different. And of course, using different trustees makes sense. But as I said, we want to make sure the provisions for the kids after the spouses are out of the picture are identical. So that's called a slat. What are the advantages and disadvantages? I love this slide. Tammy in our office does the slides, but the upside is the up arrow, the downside is the down arrow. So the upside is it reduces the taxable estate of the donor spouse, whichever spouse sets up the trust. And if we can transfer more than our half of the big exemption, 7 million, 8 million, 9 million, if we can stand to do that, then we're using exemption that's going to go away and leave us in 2026. But some people with smaller, and by smaller, I'm thinking $6 to $12 million estates, they're not so worried about the estate tax, but maybe they're worried about asset protection. What if there's a lawsuit or claim? What if we have my favorite accident that Roman describes when we do client seminars, and that is you run a red light on Blue Mound Road and you hit a van full of trial lawyers. So that is not the best moment for your estate in terms of creditor claims. And so that kind of protection is in place. But people, the examples of where asset protection can benefit you are numerous. If you've got rental properties, it's going to help you with that. Just driving a car is one of the issues that can happen. You might own a business, and so protection from lawsuits and claims that come out of that would be useful. And again, the other upside is that's in spite of the protection from estate taxes and also lawsuits and claims, your spouse has the use and enjoyment of the money. The downside, it's us. So you got to pay us to set this kind of thing up and fund the trust and move things in. And if you're trying to get things out of your taxable estate, the trust that we set up will not get a step up in basis when you die. If you're going to set it up just for asset protection, then we're able to put provisions in where you will get a step up in basis. And then if you're trying to avoid estate tax by getting things out of your taxable estate, you do have to file a gift tax return. Remember, if you go over the annual exclusion amount of $16,000 per year, you just have to start filing a tax return until you hit $12 million. So this is one of the cases where you'd end up doing that. So again, remember, if you are interested in this, you can always call us and talk to us about it. And we'll be happy to sit down and explain the things that you didn't understand from this presentation.